Hello, everyone. Thank you for joining Jennifer Schaus and Associates in our complimentary webinar series for U.S. federal government contractors. We're coming to you live from Washington, D.C. This webinar series will run for 15 weeks or on 15 Wednesdays as we cover the 15 federal departments. And as usual, these webinars are complimentary. You can find the schedule, registration links, and recordings on our website under the subcontracting section. And our data partner each week is GovSpend, formerly FedMind, and our legal perspective will be covered by a rotating government contracts attorney each Wednesday. And a little bit about us. As you can see, we provide the following services for federal contractors, including product, service, and software firms across the globe. And you can find more information about us on our website. Our webinars and newsletters reach a vast array of federal contractors, and our YouTube channel now has almost 600 complimentary webinars. So please follow our channel and give our videos a like or comment. We also offer advertising opportunities, including in this series. So if your organization is interested in reaching federal contractors, you can sponsor an event, our webinars, advertise in our newsletter, or have us post your promotional information on LinkedIn. So you can contact us at hello@jenniferschaus.com for pricing and our media kit. So there's the email right there on the screen. It'll also be sent out in today's slides. And speaking of sponsors, we'd like to take a quick moment to personally thank the organizations that help make this series possible. Special thanks to Tom Johnson and the team at Set Aside Alert for posting this webinar series in their newsletter. So please visit setasidealert.com to learn about their services for small businesses. And additionally, we'd like to thank GovEvents and also Fairfax County for sharing this webinar series on their public calendars. So please visit their websites as well for other related events on their calendars. And we'd like to thank the Virginia PTAC. Virginia PTAC is based out of GMU in Fairfax, Virginia. They offer free one-on-one counseling on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on your business location. So if you're interested in learning more, please use the links provided to contact PTAC today. And also thanks to our friends at BidSpeed. The BidSpeed platform helps you win and increase your probability of winning government contracts. They have opportunities from every federal, state, and local public source in the United States. So if you're looking for a compliance matrix, a proposal template, a strategic teaming partner, or details on an expiring contract, BidSpeed can help. BidSpeed is an official partner of the SBA's 7J Management and Technical Assistance Program. So contact BidSpeed at the email or phone number here to learn more about their services. And thank you to Gov White Papers, an online resource for content. Do you want to connect with government and military decision makers? Gov White Papers is a free resource for the public sector and supporting industries to find, post, and promote government and military related content. Explore B2G advertising solutions with our team of expert public sector marketers, including lead generation, display ads, white label content creation, email marketing, and more. Browse thousands of free white papers, ebooks, case studies, and more to stay informed on topics like healthcare, agriculture, cybersecurity, and education. Please upload your organization's plus, you can upload your organization's content for free and boost website traffic and exposure in the government community. So join Gov White Papers today to get started. All right, and today we're all here to dig into subcontracting opportunities at the Department of Agriculture. So let's take a quick look at our agenda for today. As you can see, we're going to start with panelist introductions, and we'll close out with legal insights. So our first panelist is Ms. Archisa Meehan, representing GovSpend. GovSpend is the go-to resource for finding federal contracting opportunities. So please contact Archisa for more information about the the GovSpend platform. Thank you, Archisa, for being with us. As always, we really appreciate you.
Hi, yes, it's really nice to be here as part of the subcontracting series that you all are doing this time. I think it's interesting and very helpful, especially to our small businesses. So thank you for inviting me.
Thank you. And our legal speaker today is Mr. Mark Blando, founding member of Eklund and Blando LLP. Thank you, Mark, for being with us.
Thank you. It's great to be here. Appreciate it.
Thank you. All right, so we're going to kick this off by looking at the mission statement from the Department of Agriculture. Our key takeaways are that they're focused on innovation, sustainability, and natural resources. You can read the whole thing there. We've highlighted some keywords there. And you can see here the various agencies and services within the department. We encourage you to spend some time on each of the services websites to learn more about their role and their specific mission. Because as you can see, there's a lot that goes into this department. And I'd like to draw your attention to these important links providing information on the department's small business office. So they're the first link, it's the link to the main department website, and then to the OSDBU. And also review the procurement forecast to understand what the department is buying, when they're buying, how much they're buying, and if any specific set aside or contract vehicle may be used. Lastly, the last link there is the SBA scorecard, which can help you understand the small business contracting trends and what dollars are being won by women, veterans, hub zone firms, and other disadvantaged businesses. So let's take a look at the top 10 vendors for the department. I won't read these off to you, but please make note of the top 10 vendors, who they are. They're winning the bulk of the contract dollars at the Department of Agriculture. And now we'll take a closer look at the top 5 vendors in more detail with Ms. Archisa Meehan. So Archisa, I'm gonna send it over to you now.
Cool. So let's go to the next slide. And, truly as we, from a subcontracting perspective, as we're looking at the data and getting into the information, I think it's important for people on the call to remember that you want to dig into what are the contracts being awarded for? Is there a subcontract requirement for those contracts? And even if there isn't, these are companies that you want to be talking to, especially if you are in the type of work that that company is doing. And while we are focused on, the top 10, and I'm going to go over just a few of them, the strategy remains the same. So the first one that we looked at is Produce Alliance. If you go to the next slide, this information gives you the link to the Small Business Liaison Office and where you could register as a small business vendor. The next slide. The next slide is really looking at some of the data. And, the company actually in FY20 had about $85 million in contracts, which went up to $224 million in FY21. And you could also see that within the Department of Agriculture, the contracts were really awarded or contracted by the Agricultural Marketing Service. So this is the detail that you can look at as you look at creating the relationships with the prime. Knowing what they're working with, who they're working with, what are they selling, that's all information that you want to be prepared with to have a more fruitful conversation. So next slide. And then if I go further into the detail, you could see the NAICS codes that are being used, mainly the miscellaneous food manufacturing. And I clicked into the detail of the contract the company has. You could see based on the National Interest Action that it was awarded on the COVID National Interest Action code, and that there is a commercial subcontract plan in place. That data is not made public in this case. However, this at least tells you that the company is required to have a formal commercial subcontract plan in place. So the next slide, I think, was looking at Carasoft. Everyone knows Carasoft. They do a lot of work in the technology field, and actually agriculture does have a lot of, I think, not a lot, but does, have technology-based contracts. So the next slide is going to take us into their small business SBLO's office information. Next slide. So when I look at Carasoft, and you could see, an overall view of all the various agencies that are the top agencies for Carasoft, and agriculture definitely is one of the top 5 agencies that Carasoft gets contracts from. In terms of the contracts that Carasoft is getting at the Department of Agriculture, it seems to be working with almost a lot of the bureaus, though the main administrative office is where they have the largest contract. Next slide. And then in terms of the various NAICS codes that Carasoft gets the contract, it is a lot of software and computer related NAICS codes. No surprises there. Next slide. And then also looking at the major IDIQs that contracts get awarded within Carasoft, NASA SIP 5 and the IISS GVAC are the 2 major vehicles that are used by the various agencies in awarding contracts. So next slide. So the third company that we wanted to highlight was ACE Info. Next slide. Again, the link to the SBLO or to the company information where you could contact them and sign up as a subcontractor or have your conversations with them. Next slide. So within, again, year over year, looking at the contracts the companies won, definitely did well in 2021. 2022 has taken a little bit of a dip, but agriculture, as you can see, is one of their primary agencies that they work with. Next slide. And within the Department of Agriculture, you could see that they work with the administrative office and the Forest Service office, where they did almost $70 million last fiscal year. But this year definitely is not as high as it was last year. And that could be for a variety of reasons, including the fact that, it might have had COVID funding and spending that the agency gave the company. Next slide. And looking at all the various NAICS codes, you could actually see that, they have, it's definitely computer related services that they're winning contracts under. And there's a little blip in there that actually shows you the subcontract awards by agency that the company has won. And they did win a little bit of subcontract work for the USDA. So again, just wanted to show that. Typically, if the company has made its subcontract data public, we will pull that information. So, in this case, if I don't have it on the slides, it's just because it's not available. So the next slide. And then we're also going to look at Cargill Inc. So let's go to the next slide. The link to register as a small business vendor for Cargill Inc. Next slide. Looking at the contracts that the company is winning, definitely Department of Agriculture is one of their main agencies that they are working with, specifically the Agricultural Marketing Service. They won about $13 million in FY21, and they're definitely on track or close to doing the same amount in FY22. In terms of their NAICS codes, a lot of food manufacturing and processing type of services that they provide. Next slide. And then the last company is Van Solkema Produce. Next slide. The link for the website where you could possibly reach out to them. Next slide. Department of Agriculture was their main, one of the main agencies last year, but we see nothing for this fiscal year. And I think, again, where we see these companies that have done a large amount in FY21 could be definitely related to purchases, manufacturing that had to be done due to under the COVID NIA code. Next slide. I don't think there is much after this, and I will stop right here. So again, you know, the idea of giving you a quick overview of the top companies is to let you know what they're doing, and sort of show you how you could mine the existing data that is out there to create your relationships and, you know, marketing plan. So, and that takes us straight into the next slide for marketing best practices.
Thank you, Archisa, for all the data and your insights. We really appreciate that. So now we're just going to go through some marketing best practices. So we have listed here the basics for marketing your services to the top primes. Most importantly, you should use the tools available on sam.gov or the GovSpend platform to conduct research on the primes and the expiring contracts. Use the prime's website, their newsletter, and event calendars, as well as social media to learn more about them and then connect with them. Lastly, set yourself apart and lead with your capabilities, not your socioeconomic status. Bring a specific opportunity to the prime and work with the SBLOs, the small business liaison officers. They're your advocates, so definitely work with them. All right, and now we're going to go over the legal considerations and best practices. Please note that we've covered the federal acquisition regulations on the Department of Agriculture earlier this year, so you can find the YouTube recording here on the screen. You can also find it on our website and our YouTube channel as well. All right, so I'm going to pass it over to Mark Blando, who will be finishing out this presentation for us.
Excellent. And before you go on mute, Madeline, should I still plan on just about 15 minutes, or how long should I plan to go for?
You just go ahead and share all of the information you think is relevant for today. Thank you, Mark.
Sounds good. Well, good afternoon, everyone. Actually, it's a good morning for me and anyone else here in the Midwest. My name is Mark Blando, and I am a partner at the law firm of Eklund & Blando. We are based in Minneapolis, and we're basically established as a government contract boutique law firm here in the Midwest. I did originally go to law school and practice government contracts in DC before moving out here, but happy to have a kind of outside the Beltway outpost for government contract law. So I've been practicing government contracts for 25 plus years now, and focusing primarily on litigation. And interestingly, I don't know if Jennifer was aware of this when she asked me to speak on this session regarding the Department of Agriculture, but quite fortuitously, a lot of our litigation has been involving the Department of Agriculture, which I think helps to show how diverse an agency it is. Madeline had showed the list of the different sub-agencies within the USDA, and it runs quite a wide range. I know a lot of people think of just USDA as the folks that stamp the meat you see at the supermarket, but they're also very involved in rural housing, and it's that housing connection, you know, creating affordable housing in rural areas that gave rise to one of the very few government contract cases that have gone all the way to the US Supreme Court. which was one of our cases. It's called Franconia Associates versus United States. It's not on the radar of a lot of government contractors because it was not a FAR contract. In other words, it was not a contract for goods or services, but rather related to affordable housing, and that is why it was not bound up in any of the requirements of the FAR. So kind of a unique government contract. We've also had some cases involving the Forest Service, which not everyone knows is also an agency within agriculture, not the Department of Interior, like the Park Services, which has an interesting history of its own. So that's a little bit about me and my firm. We can go to the next slide. And I just have a summary of some of we're going to talk about a few of the best practices from a legal perspective to be aware of when you're subcontracting, whether it's with USDA or any government federal agency. And then we'll talk for a few minutes about flow downs, which is probably one of the most important things to be aware of if you are working as a subcontractor on a government contract. And as Madeline mentioned, there's already a video out there with covering the FAR supplement that covers the Agriculture Department. And I'll just highlight a few of the clauses in there that specifically relate to subcontracting. All right, so my first piece of advice is to just know who you're dealing with. As a subcontractor, you have an opportunity to work with a prime contractor, and you want to make sure you do your homework to know if they are someone that you do want to do business with. You know, in any government contract, responsibility or the ethics and wherewithal of the prime contractor is always a key issue, and that's something that the federal government is the primarily responsible party to determine. But as a subcontractor, you also want to do your own homework and just know if it's not a company you've done business with before, or even if it is, once you get into the government contract realm, there's other issues and red flags you might want to look out for. And the SAM system is, of course, a good starting point to find out about your potential partner. Connected to SAM is a list called the Excluded Parties List system, which will list any contractors that are suspended or debarred, in which case they're not going to be doing any business with the federal government in the first place. But there is always a chance that they are subject to an administrative agreement under which, you know, a contractor who has had some issues, perhaps False Claims Act allegations, and has negotiated a settlement with the government, may avoid suspension and debarment by entering into an administrative agreement, which basically means that it's kind of like a probation. So they're subject to several requirements and monitoring and auditing by a third party, but they can continue to do work for the federal government. So that's one key thing to find out about, is whether they are subject to an administrative agreement. Have they had any even allegations of any wrongdoing, particularly under the False Claims Act, which is a huge hammer that the government has in monitoring the work of its prime contractors as well as subcontractors. And you want to do some Google research as well. You know, maybe the company hasn't been in any trouble, but the principal has been. Or maybe it's a joint venture, and the joint venture itself hasn't had any issues, but the individual companies that make up that joint venture or partnership, or if it's a teaming arrangement, the members of that team, maybe someone involved has had some history that you should be aware of. Then in addition to that, of course, you want to know what agency it is, and if there's any special interests or FAR clauses or supplemental FAR clauses that apply specifically to that agency. All right, so number 2 is getting into the terms of your contract with the prime contractor, your subcontractor. So typically the way this is going to start is the prime will say, we'd love you to be involved in this contract. Here's our proposed contract terms. And, you know, this session is not a plug for hiring a lawyer, but there are many instances in which that is something that you should very much consider, particularly when you get that first proposed set of contract terms from the prime. Because one thing that it will do is include a myriad of FAR clauses, sometimes just in a long list of clauses that are stated to be incorporated by reference. And as we'll talk about in a moment regarding flow downs, you want to know what actually is required to be flowed down and what is not required, and what is fairly essential for the prime contractor to need to have in that subcontract and what is not. And so that's an important step. But beyond the required flow downs, there's also the question of all the other terms, the non-FAR or business terms, just the basic price, delivery terms, warranty, limitation on liability, termination clauses, cybersecurity, big issue now, of course, all these different clauses that you'll want to negotiate. And you as the sub may have your own form that you like to use, and that is often a big part of the negotiation, is to try to marry your form and the prime's form. Typically, again, the prime is going to be very forceful in saying, this is our standard contract, and this, if you want to do work with us, this is what you have to abide by. But again, that doesn't mean you can't negotiate it or incorporate some of the terms from your standard form. Another issue related to that to be aware of is called the battle of the forms, where if they send a contract and you sign it, and you send a contract and they sign that, or more typically, let's say there's a master contract that theirs is their form, but under that master contract, purchase orders are issued by you as the sub that also have terms. And then later on down the road, you get into a dispute, and the question is, well, whose terms are going to prevail? And the answer to that, unfortunately, is basically that it depends, and it'll depend on the timing of what came first, and also the language. You know, if your purchase order says these terms supersede any and all terms related to this issue, say on you know, limitation of liability, then typically the court's going to say that prevails because the other side agreed that it would supersede its terms. But it's all going to come down to how those terms compare and what the court believes should take precedence. So the battle of the forms is something to be very aware of. You want to make sure that there's clarity in terms of what the actual clauses in that contract, whether they're from the FAR or other items that you negotiate with the prime, are actually the prevailing terms. And once you have those terms agreed to, moving to number 3, you want to make sure you understand all of those clauses. And again, a lot of them are going to be FAR clauses that are incorporated by reference, and you may not even see the text of the clause in the contract. It'll just say, you know, FAR clause 52.272 subpart B is hereby incorporated by reference. Well, if you don't know what that part 52 clause is, you better have the FAR and look it up and make sure you know what all those terms are. The other thing to be aware of is in subcontract, it's very interesting because the prime contract, of course, is directly with the federal government, and that means that the prime contractor is in what we call privity of contract with the government. And being in privity just means that those are the two parties between whom all of the rights and obligations flow. So generally there's no, except for in rare circumstances where you can have something like a third-party beneficiary, typically all the terms of a contract only apply to the two parties directly to that contract. And that means that the prime is the only entity that actually sits in a direct contractual relationship with the government. And that means that its terms are going to be interpreted by a court with proper jurisdiction, one of the specialized courts, as opposed to the subcontract, which is only between two private parties, right? The government is not a party to that subcontract, which means that state law is going to apply to the interpretation of any clauses in there. Now, if it's so, that leads to the interesting situation where a state court could be interpreting a FAR clause, which is, as you can imagine, out of the typical state court's judge's depth, but they are going to defer to how the federal court, such as the Court of Federal Claims, interprets that contract clause from the FAR. But all the other clauses that have nothing to do with the FAR are going to be just based on state contract law. So that's an important distinction to be aware of. Let's go to the next slide. Now, many of you may be small businesses, so if you don't know if you are, then that would of course be the first step, is to look it up. Under the government standards, you don't actually have to be what most people would consider as necessarily small to qualify as a small business under what are called the NAICS codes, the North American Industry Classification System, which sometimes go to the number of employees, but more often go to dollar values of revenue, typically over a 3-year average period. So first, if you're not sure, find out if you're small. If you are, then as many of you know, there are many advantages. As a prime contractor, there's set-asides and preferences. But in terms of subcontracts, the key thing to be aware of is that most prime contractors will be obligated to have a small business subcontracting plan. And that's right out of the FAR, that they have changed the dollar threshold over time, but right now it's at 750 grand. And of course, there's exceptions for different types of contracts. But the typical case, it would be any contract valued at over 750 grand. That prime is required to implement and carry out a small business subcontracting plan, which will set out goals for doing business with small businesses generally, as well as the individual types of small businesses, minority-owned, service-disabled, veteran-owned, hub zone located small businesses, woman-owned, and small disadvantaged businesses. So pretty much any company that does substantial business with the federal government is required to have one of these plans, and they are monitored. You know, the government is going to make sure that the company is doing what it can to fulfill those goals. So that's where the opportunities really lie as a subcontractor, and your local PTAC will likely have different events for small businesses to get to connect with large businesses and find out, be able to sell what you may be able to offer that prime to help them fulfill their obligations under their small business subcontracting plan. The last best practice I'll mention has to do with when things go wrong, which hopefully they won't, but you always have to be prepared for that. And thinking back to the contract terms, you may want to have a clause. You will have some clause in there that talks about choice of venue and choice of law, and whether you can have a jury trial or a trial without a jury, or arbitration is very popular now. The prime may want you to have a clause that says any disputes have to go to arbitration. So be aware that, again, you get an interesting dichotomy between the prime contractor's relationship with the federal government and your relationship with the prime as two private entities. So if the prime wants to sue the government, then that would occur in either the Court of Federal Claims or one of the boards of contract appeals, which are basically the venues that have been created for money claims, particularly contract claims against the federal government. The subcontractor cannot do that. Let's say the government causes delays that impact the subcontractor. And there are situations where some government action may impact the sub, but not the prime. Could cause the prime some delays because it only affects their work and doesn't affect or delay the prime's work. So the sub may want to assert a claim against the government, but will find that it is unable to do so because of, again, that lack of privity. So the only way that that can happen is if the prime agrees to do what is called sponsor the claim against the government, in which case the prime basically acts as a go-between, as a pass-through entity for the sub to assert that claim. So in name, it's really the prime bringing that claim against the government, but it simply is asserting the very claim that the subcontractor has based on the potential liability to the prime because of its relationship in that contracting tree. So that's one avenue, and that's really the only avenue if the sub wants to assert and receive damages from the government itself. Otherwise, if the dispute is with the prime, that will have to be brought in a state court, and where again you get the interesting situation of a state court trying to understand the terms of a contract that includes clauses that are unique to the federal government. But that is where those claims would have to be brought. That it could be a federal court, but point there is that it's in the state's system, either the federal court in that state or the actual courts of that state itself, depending on whether there's a diversity jurisdiction between the two parties. All right, let's go to the next slide. So we've already mentioned flow downs a couple of times because they are such a critical component of being a subcontractor in the government contract world. And a flow down is simply a clause that is required by the government to be flowed down to subcontractors. But it's can go further than that, because sometimes it will have to be flowed down to the subcontractors or the second tier subcontractors. Sometimes there's a distinction between suppliers and subcontractors, and some clauses may need to be flowed down to suppliers as well as subcontractors. And again, the subcontractors can be at any number of levels, all depending on what the FAR says. So that's always the starting point. And we look at a two-step process to figure out what your flow downs are and whether they apply and how far they have to be flowed downstream. And I like to think of the FAR as basically being set up into two sections. The front half of the book, and it's really much more than half, but those are the terms that say, here's what your contract has to say. If your contract, going back to our small business subcontracting plan example, if your subcontract is valued at over 750 grand, you have to have a small business subcontracting plan. And the way it says that is if your prime contract is valued at over that amount, then insert the clause found at part 52 blank blank blank. In this case, it's 52.219-9, I believe. And so that in that back half of the book is all part 52, which has all of the clauses that have to be inserted in different circumstances. So you've got your implementing clause, again, that says here's what you have to include depending on either the dollar value of the contract, the type of contract, whether it's a contract fixed price or cost reimbursement, is it construction, where a lot of special requirements come in, is it for commercial items? That dictates whether a certain clause needs to be in there or not. And then part two is the actual clause verbatim in the back part of the FAR that tells you what clause has to be included. And it will also say in the implementing part whether that needs to be flowed down. And this is where we get into what actually needs to be flowed down to you as a sub and what does not. So there are three types of clauses that may or may not have to be flowed down: the mandatory clauses, essential clauses, and optional clauses. And so going back to our example of the sub and the prime negotiating the terms of the contract, that's always, we've represented parties on both sides of this, both the prime and the sub, and the prime is always going to want to push down as many clauses as they can and protect itself to the maximum extent possible. But whenever we're representing a sub, our focus is always, well, wait a minute, why are you flowing this down to us? This doesn't even apply to this type of contract. Your prime contract with the government may be a cost-based contract, so you've got this clause, but our subcontract with you is fixed price. So this, cost accounting clause, for example, doesn't apply here. And so you'll have all kinds of examples like that. You know, maybe you are bound to this requirement because your contract is over a certain dollar amount, but our subcontract is way below that dollar amount, so we're not subject to that requirement. And often the prime will say, well, we'll just have it say, we will include this clause if it's applicable, under the theory that, you know, if you're right, if it turns out that because your subcontract is on a fixed price basis, you're not subject to that, then it just won't apply. But as a sub, you want to say, well, no, it's clear that this doesn't apply to this type of subcontract. It's not required to be flowed down, so it shouldn't be in there. And so that all goes to knowing the FAR and what is actually mandatory. You know, what does the FAR actually say must be flowed down to your specific type of subcontract, and what does not. So those are the mandatory clauses. Next, we have what we call essential clauses, which are not per the FAR required to be flowed down. They may be FAR clauses, they may be non-FAR clauses, but there are other things where the prime would say, listen, we have to have this clause in here, and it's a non-starter if we don't have this, say, limitation of liability, if we don't have this warranty, for example, then it's not reasonable or commercially feasible for us to do this deal. And that's where it's more of a typical contract negotiation on what should be required or not. A very good example here is the termination for convenience clause. So every government prime contract must include a T for C clause, a clause that says if the government decides for any reason or really no reason at all that it doesn't want to continue with performance, it can terminate the contract even if there's been no default or error by the contractor. And that's because that's just the nature of the government. If their interests change, if they don't want to buy this kind of tank anymore and they want to move to faster, fleeter, smaller, lighter tanks, then they can cancel a whole program. Doesn't mean that the prime is without any rights, but it is to get damages, at least for the work that they've done to date. But that's so essential that I'll mention another important legal concept that applies to government contracting and can trickle down to subcontracting, which is the Christian doctrine. And that is the concept that if a clause is important to the government's interests, and let's say the contracting officer simply forgets to include it, the court is going to read that clause into the contract. In other words, they're going to pretend it's there even though it's not. And it's called the Christian doctrine because it comes out of a case that actually involved the clause I just mentioned, the termination for convenience clause. They said that's such an important clause and it is required by the FAR. That's the key. If the regulations say this clause must be here and it is an important clause for the government's interests, that's a component of it too, then you've got to pretend it's there whether it's actually there in print or not. The termination for convenience clause is such a clause, and that is a good example also of an essential flow down clause, because the prime is going to be well within its rights to say, listen, if we get terminated, there's nothing we can do about it. So we need to make sure we have the right to terminate this subcontract for convenience as well. Otherwise, you know, we'll get caught in the crosshairs here with, you know, no more payment from the government, but still continuing obligations to you to pay you for work that, you know, can't be done anymore. So in that situation, you know, we would always advise a sub, yes, that is very reasonable, in fact, necessary for the prime to have that termination for convenience clause in the contract. There's others that may be more on the fringes where the prime says this is essential and you as the sub will say, no, it's really not so essential. And then you'll have to negotiate whether it should be in the contract or not, or what form it should be in. And that brings us to the optional clauses, which are the ones that truly don't need to be there and are just simply a matter of negotiation between you and the prime contractor as to whether that clause could or should be included in your contract or not. All right, let's go to the next slide. Okay, one other important thing to be aware of in flow downs is commercial items. So this is a major regime within federal government contracting that goes back to the 90s, where the government decided, listen, we ought to really act more like commercial buyers and not try to buy everything, for example, based on these complicated specifications. You know, why should we create a 30-page specification on how to make an oatmeal cookie? And by the way, that's a real thing. When we know there's lots of cookie companies out there that are available at a reasonable price, and we know the price is reasonable because it's subject to competition on the open market. And so the idea of the commercial item regime is, let's not have so many onerous government requirements imposed on these commercial companies who we want to sell to us as the federal government, right? The more companies that can sell to us, the more competition, prices go down, quality goes up, everybody wins, right? And then you bring more companies into the fold as primes and subcontractors. So you would think that with all those safety guards based on the commercial marketplace, that there wouldn't be a whole lot of government requirements that come in. And that was kind of the concept, but in reality, it's turned out to be a bit different in that there are still many, many clauses and different, really dozens and dozens of clauses of different types, some, you know, based on being mandatory government clauses or depending on what type of contract, what the commercial item contract is for. A good deal of clauses that are imposed, and we won't go through them here today, but just know generally as a subcontractor, if what you're selling is a commercial item, then you want to make sure that the prime is only flowing down to you the clauses that do in fact apply to commercial items. If you don't know if your product is in fact a commercial item, then that is definitely something worth taking a close look at. It is a very broad definition. I believe it's the longest definition in the FAR, and it doesn't just cover what you would typically think, you know, things that you can buy at the supermarket, but it also covers something that's available on the commercial marketplace, subject to some modifications to meet the government needs, or something that is in development that will be available on the commercial marketplace. It can even be services. So any services that fit that definition of, you know, something that's either available or will be available or is similar to something that's available on the market can be a commercial item. So that's often the number one step that you want to look at as a subcontractor is, you know, what good or service am I providing to the prime, and does it qualify as a commercial item? Because if it does, it is going to significantly restrict what clauses can be flowed down to you or not. Because the prime contract doesn't necessarily have to be for a commercial item for the subcontract to be for a commercial item. And that's why, again, the prime may try to flow down every clause in its non-commercial prime contract, when in fact you can push back and say, no, just because you're selling something that's not a commercial item doesn't mean you can flow those requirements down to me, because what I'm selling you, prime, is in fact a commercial item. Within that, also be aware of COTS items. That stands for commercial off the shelf, which is a subcategory of commercial items. And that's where you really do get the benefit of having very few, or at least fewer clauses that apply to your subcontract. So if it's a COTS item, meaning the strictly products that really are available to the general marketplace in substantial quantities, then you can further narrow down a bit what actually will apply to your contract. So very important to know about commercial items requirements when you're looking at flow downs. All right, and I believe the next slide is our last one. So finally, you do want to be aware of any specific requirements that apply based on the agency that the prime contract is with. And so we've got the FAR, the Federal Acquisition Regulation, and then there's a variety of FAR supplements The big one, of course, is the DFARS, the Department of Defense FAR supplement. But pretty much every agency has their own FAR supplement, which don't replace, but are in addition to the requirements of the FAR. And here we've got the Agriculture Acquisition Regulation, or the AGAR, which does not have a ton of provisions. It's got a lot of clauses relevant to prime contractors with agriculture. Just a few that relate to subcontracting that are worth mention. We've already talked about subcontracting plans. The AGAR does have a provision that talks about those small business subcontracting plans, just emphasizing the agency's particular emphasis on small business. It says that it's the policy of the USDA to provide maximum practicable contracting and subcontracting opportunities for small businesses. So that's a special interest of the Department of Agriculture, although you will see similar policy statements for other agencies. But that's something that can work to your advantage as a subcontractor working within the Department of Agriculture. Kickbacks, there is a specific clause that talks about the prime contractor being required to report any suspected violations of the Anti-Kickback Act. And so that is something to be aware of as far as your dealings with the prime, that note that they are going to be bound by a very specific requirement, a mandatory reporting requirement related to kickbacks. Easily avoided if you just don't engage in any kickbacks, of course. And then finally, security, national security and cybersecurity is a growing issue, with many companies now being required to have a cybersecurity plan in place. And there is a AGAR provision here as well related to national security that basically says any requirements of the prime contract related to security need to be passed on to the subs. So anything security related, basically, you can expect that the prime will say, hey, this is tying things together here. This is one of the mandatory clauses that we do have to flow down to you. We don't have a choice because these AGAR regulations require it. So that's my overview of some of the legal issues you should be aware of if you're doing business with a prime, who in turn is working with, most of this applies to any government agency, and particularly with the Department of Agriculture. And so thank you. That concludes my comments.
Thank you, Mark, for all your great insights in your presentation today. You can find the contact information for our speakers there. There's Mark's email, and then Archisa's as well. So if you have any questions, you can contact them directly. Thank you to everyone who participated today. The recording and the slides will be available within about 24 hours, though usually even less time. So we thank you for attending, and we look forward to seeing you next week. Next week, we'll be covering subcontracting opportunities at the Department of Commerce. So this concludes the webinar. Have a great day.